Hola a todos y bienvenidos de nuevo al canal. Hoy profundizamos en un tema crucial que afecta el bienestar de muchos niños and adolescents. The legal measures of family placement or placement in a care facility. We'll be exploring the fundamental principles, characteristics, and procedures that govern how and when a child can be placed outside their family of origin for their protection. While the specifics we'll discuss are based on Venezuelan law, the core principles of prioritizing a child's best interests are universal and offer valuable insights. So, what exactly is family placement? Essentially, it's a legal protection measure for children and adolescents who are temporarily unable to live with their original family. It's a way to provide them with a substitute family environment. The legal framework for this is detailed in the Organic Law for the Protection of Children and Adolescents, often referred to as LOPNNA. These provisions aim to create a stable and nurturing environment until a permanent solution can be found. It's important to note that these are part of a broader set of rules governing substitute families, all designed with the child's welfare as the top priority. Let's break down the key characteristics of this measure. First, and this is critical, it is always a judicial measure. This means only a protection court can make this decision. No administrative body has the authority to order a family placement. The case is heard by the trial chamber of the Child and Adolescent Protection Court, specifically under its jurisdiction for family matters. The specific court that handles the case is determined by where the child or adolescent resides. This ensures that the decision is made with the full weight and consideration of the judicial system, safeguarding the rights of everyone involved. Second, family placement is an autonomous measure. What does this mean? While it could potentially lead to adoption down the road, which is the most permanent and secure form of substitute family, it doesn't have to. Family placement serves to protect children who might not be eligible for adoption or for whom no adoptive parents have come forward. It provides a safe and loving home, filling a vital gap and ensuring that every child receives care regardless of their path to a permanent family. Third, this is a measure that is subject to review. It's not a set-it-and-forget-it decision. The law requires that the protection measure be reviewed at least every 6 months. This is because circumstances can change. The court can modify, replace, or even revoke the placement at any time if it's in the child's best interest. A fundamental part of this review process is hearing the opinion of the child or adolescent themselves, provided they are old enough to express it. Additionally, the judge will require social and psychological evaluations from the court's multidisciplinary team to ensure the placement continues to be the right fit. Fourth, it is a temporary measure. The law defines it as a transitional arrangement that lasts while a more permanent solution, like returning to their family of origin or adoption, is being determined. The law itself outlines the specific conditions under which the placement can end, which we'll touch on a bit later. Now, you might have heard the phrase family placement or placement in a care facility. The word or might suggest they are interchangeable, but they are absolutely not. The law and legal experts strongly emphasize a preference. The primary goal is always to place a child in a family setting. The entire philosophy is to replicate a family environment as closely as possible. Institutionalization or placing a child in a care facility is always the last resort. Legal scholar Heidi Barrios explains this beautifully. She notes that admitting the need for care facilities was a practical necessity. It's simply not always possible to find a substitute family for every single child in need. Therefore, the law mandates that all possibilities for a family placement must be completely exhausted first. Only when it is proven that a suitable family cannot be found can a child be placed in a care facility, and even then, it must be the most appropriate facility for that specific child's needs and characteristics. These care facilities are public interest institutions, which can be public, private, or mixed, that run specific programs and projects for the children in their care. This brings us to a special short-term measure called abrigo, which translates to shelter. This is a provisional and exceptional measure ordered not by a court, but by an administrative body called the Protection Council. It's a temporary placement, either in a substitute family or a care facility, intended as a transition. It's used when a child cannot be immediately returned to their family of origin and a more permanent decision is pending. The key here is its duration. A shelter placement cannot exceed 30 days. If the situation isn't resolved within that month, the Protection Council must notify the court, which will then take over and decide on the next steps, which could include a formal family placement. So, shelter is a rapid emergency response, whereas family placement is a more structured, medium-term judicial decision. They serve different purposes but can work in sequence to protect a child. So, when does a formal family placement become necessary? The law outlines 3 primary scenarios. First, it can be ordered if a child has been in a temporary shelter for 30 days and their case still has unbeen resolved administratively. Second, it's used when establishing or continuing a guardianship is impossible. And third, it applies in cases where parents have had their parental authority legally terminated or it has been extinguished for other reasons. The law also establishes a clear order of preference for who can be granted a placement. The priority is always to exhaust all possibilities of placing the child within their extended family. Only if that is not feasible will the court look to other individuals. The placement can be granted to a single person, a married couple, or an unmarried couple in a stable, legally recognized relationship. The most important qualification is that these individuals must have the conditions to ensure the child's physical protection and their moral, educational, and cultural development. Interestingly, if a parent had already entrusted their child's upbringing to a third party who is deemed suitable, the court will consider that person as the first option for a formal family placement. To ensure quality of care, people who wish to be considered for family placement must be enrolled in a placement program that provides training and supervision. There are exceptions for urgent cases, but even then, the person must enroll in a program immediately after. The protection councils are required to keep a register of all individuals and families who are eligible and approved for placements. Once a child is in placement, the decisions made by the person with custody regarding the child's upbringing take precedence over the opinions of the biological parents. This is to ensure stability and clear authority in the child's daily life. Finally, how does a family placement end? It can end in two main ways. The first is an absolute termination. This happens when the child is reintegrated into their family of origin because the parents have regained their full parental rights. It also ends if a permanent solution is found, such as adoption, even if it's the foster family themselves who adopt the child. The second way it can end is relatively. This means the placement with one particular person or family ends, but it is immediately substituted with another placement. This can happen if the caregiver voluntarily decides they can no longer continue. In this case, they must inform the judge, who will then decide the next steps. They can never hand the child over to someone else without the court's express permission. It can also be terminated by a judicial decision. The court can revoke the placement at any time if the child's best interests require it. This can be requested by the adolescent themselves, the parents, relatives, the public ministry, or anyone with direct knowledge of circumstances that justify a change. In conclusion, family placement is a vital judicial measure of protection for children temporarily deprived of their family environment. The system is designed to first involve relatives, but if that's not possible, it seeks out other caring individuals who can provide a safe and nurturing home. Prioritizing human qualities over economic status. The law is unequivocal. A family setting is always the first and best choice. Only when every family-based option has been exhausted should placement in a care facility be considered. The goal is always to provide the most supportive, family-like environment possible to help a child thrive. Thank you so much for watching. I hope this explanation was clear and helpful. If you found value in this video, please give it a thumbs up. Subscribe to the channel for more content and feel free to share your thoughts in the comments below. See you next time.